How are you doing?
Good.
Great. Welcome back to Patent Beast podcast. And today we're talking about the Uspto. It's making a lot of updates. Can we talk about it a little bit?
Yeah, they're making good changes. You know, they're trying. They like to think of us as customers. I'm not sure they really do, but that's what they
claim.
That's what they claim. Yeah. So there's a couple new things that have come up which are really useful. Let me talk about the track one. We've been using track one for several years. Normally it takes 18 months, sometimes 20 months, 22 months, whatever, between the time you file your application and the time you get a first office action. The examiner actually looks at it. That's a long time, right? In pharmaceutical, you don't care because you can't sell it anyway for another 5 years till you get it past FDA. But in some fields like computer technology, you want it now. Robots, you want it now.
Especially in those,
So this fast track, track one it's called, you're limited to 30 claims. You're limited to 3 independent claims. For a small entity, it'll cost you an extra, I forget, $1,700 or $1,800. They will look at it, first office action, within 3 to 5 months. And we've even gotten it in 1 to 2 months. So that's really good. And then there's a new one, right? Did I tell you about the new one?
Yeah, tell me about it.
That's the streamlined claim set.
That sounds good.
So now, if you only have 10 claims and only 1 independent claim, you can file with this streamlined claim set. And it'll also be as fast and doesn't cost anything.
Wow. Well, that's a big improvement.
Yeah, exactly. Wow. So that's a big improvement. And then on the other end, if you don't do those things, there's a program. There are 2 programs that came out in May, just this year. And one of them is, I forget what it's called, the first office action estimator. So as you're going along, it will say, you've got 6 months to go. You've got 3 months to go. You've got a year to go. We filed a reissue application in 2022, 4 years ago, and they still haven't gotten to it. So we're complaining about that. But anyway, it'd be nice to know it's been given to an examiner. Well, I don't know if the examiner went on vacation for a couple of years.
You don't know the status of it.
We don't know the status of it. So at least tell us what's going on, because the client wants to know. So they're going to tell you. They're going to estimate it. And then there's a pre-docketing notice, 3 months before they're supposed to actually send it. Examiner's supposed to look at it before they're supposed to get it docketed. Actually, it's docketing. They will give you an opportunity to withdraw it, because maybe all this year's gone by and you said it's not worth it anymore. Technology has moved on. Maybe you found some prior art that the thing's not even valid anymore. You have an opportunity. You get your money back for the search fee, and you get money back for extra claim fee. So you know,
that's a really good.
That's good, because sometimes that happens.
Absolutely.
Right. And then here's really one of my favorite ones that's happened. We don't do a lot of appealing, right? Because it takes too long, it's too expensive, and typically we get the patents allowed anyway, right? Now, up until Alice, with thousands of patents, I could really name 5, maybe one hand I could count the ones we couldn't get. After Alice, it's a different story. Anyway, so let's say you're appealing and it's a 101 issue, right? So subject matter eligibility. You say it's eligible, the patent examiner says no, she doesn't have any evidence really. You're allowed to file a declaration, right? And it's a subject matter eligibility declaration called a SMEG, or whatever it is. And you're allowed to file these things, and in the declaration you say why, give some facts as to why it's a technological problem, and a technological solution to that technological problem, and then the examiner has to consider it. And it has to consider it, and if the examiner is going to discount it, has to consider it by preponderance of the evidence is the standard.
That's
so not clear and convincing, not beyond a reasonable doubt, like in a criminal court, but preponderance of the evidence. I was just at the U.S. Patent Office for PTAB Patent Trial and Appeals Board last week.
And you had a full experience.
We were doing exactly that very same issue. So we had declarations on file. The examiner did not consider it properly. The examiner considered it, but wasn't able to counter it with any evidence. And so we think we should win because we had evidence, and the examiner has nothing to counter it. So we think we have to win on that one issue. And then there's one more thing about PTAB, the Patent, Trademark, and Appeals Board. There is now a process. You can file a 452 petition to speed up that process. Because, I mean, it used to be a long time, 6 months, 8 months, 9 months, and now they're supposed to do it in only a couple months, maybe 2 to 3 months, but it's more like 2 months now. So kudos to the Patent Office. They're moving forward. I think the statistics are they've gone from a year ago, January 2025, I'm going to be not accurate, but 830,000 applicants in the hopper, applications, and now it's down to 780 or something. So 830 to 780, down by whatever that is, 7-8%. Big benefit. So
absolutely.
Kudos to the Patent Office.
Great updates. Absolutely.
Thanks.
Well, thanks, Bob. And we'll see you guys next time at another episode of Patent Beast. Take care.